Yes, sir. I'm just reading out some of the programs. Just give the pen.
Just one word.
Unlike demands of a formal democracy, the hallmark of a substantive democracy, and if it misses to a liberal democracy, must be borne in mind. Democracy is inextricably intertwined with power to the people. The ballot is more potent than the most powerful gun. Democracy facilitates a peaceful revolution at the hands of the common man if elections are held in a free and fair manner. Elections can be conflated with a non-violent coup capable of unseating the most seemingly powerful governing parties if they do not perform to fulfill the aspirations of the governed. Democracy is meaningful only if the sublime goals enshrined in the preamble to the Constitution receive the undivided attention of the rulers, namely social, political, and economic justice. The concepts of liberty, equality, and fraternity must not be strange bedfellows to the ruling class. Secularism, a basic feature of the Constitution, must inform all actions of the state, and therefore cannot be spurned, but must be observed in letter and spirit. Democracy can be achieved only when the governing dispensation sincerely endeavors to observe the fundamental rights in letter and spirit. Democracy also, needless to say, will become fragile and may collapse if only lip service is paid to the rule of law. Then we would therefore find that the Election Commission of India has been charged with the duty and blessed with extraordinary powers to hold elections in both parliament and state legislatures from time to time. This is an enormous task. The power it possesses under Article 324 is plenary. It is only subject to any law which may be made by parliament or by the state legislature. Undoubtedly, the Election Commission is duty bound to act in a fair and legal manner. It must observe the provisions of the Constitution and abide by the directions of the court. The same being done, it can draw upon a nearly infinite reservoir of power. Once a poll is notified, which again is a call to be taken by the Election Commission itself, and indeed capable of being misused and subject of considerable controversy, if bias or subservience to the powers that be is betrayed. It assumes unusual powers. Its writ lies across governments over the length and breadth of the country. Officers of the government who come under its charge become subject to the superintendence of the Commission. The fate of political parties and its candidates, and therefore of democracy itself, to a great measure is allowed to rest in the hands of the Election Commission. While there may be officers who assist the Commission, vitally important decisions have to be taken by those at the helm of the affairs. It is the Chief Election Commissioner and the Election Commissioner at whose table the buck must stop. It is in this scenario we bear in mind that when a decision is taken, the process of holding of the poll, that subject to the proceedings which are initiated in courts, which conduce to the effective holding of the poll, any proceeding which seeks to bring the election process under a shadow is tabooed. The significance of this aspect is that it adds to the enormity of the powers and responsibility of the Election Commission. Awaiting the outcome of the poll to question the election before the tribunal may result in many illegal, unfair, and malafide decisions by the Election Commission passing muster for the deed. Once the election results are out, the matter is largely reduced to a fait accompli. The basic and underlying principle central to democracy is power to the people through the ballot. Abraham Lincoln declared democracy to be government of the people, by the people, and for the people. A political party or a group or a coalition assumes the reins of governance. The purpose of achieving power is to run the government. No doubt, the government must be run in accordance with the dictate of the Constitution and the laws. Political parties, not unnaturally, come out with manifestos containing a charter of promises they intend to keep. Without attaining power, men organized as political parties cannot achieve their goals. Power becomes therefore a means to an end. The goal can only be governed so that the lofty aims enshrined in the directive principles are achieved while observing the fundamental rights as also the mandate of all the laws. What is contemplated is a lawful government. So far, so good. But what, however, is disturbing and forms, as we understand, the substratum of the complaints of the petitioner is the pollution of the stream or the sullying of the electoral process which precedes the gaining of power can hence justify the means. There can be no doubt that the strength of a democracy and its credibility and therefore its enduring nature must depend upon the means employed to gain power, being as fair as the conduct of the government after the assumption of power by it. The assumption of power itself through the electoral process in the democracy, in the democracy cannot and should not be perceived as an end. The end at any rate cannot justify the means. The means to gain power in a democracy must remain wholly pure and abide by the constitution and the laws. An unrelenting abuse of the electoral process over a period of time is the surest way to the grave of the democracy. Democracy can succeed only insofar as all stakeholders uncompromisingly work at it. And the most important aspect of democracy is the very process, the electoral process, the purity of which alone will truly reflect the will of the people. So the fruits of democracy are truly reaped. The essential hallmark of a genuine democracy is the transformation of the ruled into a citizenry clothed with rights, which in the case of the Indian Constitution also consist of fundamental rights, which are also being freely exercised. And the contribution and radical change of the ruler from an emperor to a public servant, with the accumulation of wealth and the emergence of near monopolies or duopolies, and the rise of certain sections in the media, the propensity for the electoral process to be afflicted with the vice of wholly unfair means, being overlooked by those who are the guardians of the rights of the citizenry, as declared by this court, would spell disastrous consequences. The cardinal importance of a fiercely independent, honest, competent, and fair election commission must be tested on the anvil of the rule of law, as also the grand mandate of equality. We expatiate. The rule of law is a very bedrock of a democratic form of governance. It simply means that men and their affairs are governed by pre-announced norms. It averts a democratic government brought to power by the strength of the ballot, betraying their trust and lapsing into a government of caprice, nepotism, and finally despotism. It is a promise of avoidance of these vices which persuades men to embrace a democratic form of government. An election commission which does not ensure free and fair poll as per the rules of the game guarantees the breakdown of the foundation of the rule of law. Equally, the sterling qualities which we have described, which must be possessed by an election commission, is indispensable for an unquestionable adherence to the guarantee of equality in Article 14. In the wide spectrum of powers, if the election commission exercises them unfairly or illegally, as much as he refuses to exercise power, when such exercise becomes a duty, it has a telling and chilling effect on the fortunes of the political parties. Inequality in the matter of treatment of political parties who are otherwise similarly circumstanced unquestionably breaches the mandate of Article 14. Political parties must be viewed as organizations representing the hopes and aspirations of its constituents or citizens. The electorate are ordinarily supporters or adherents of one or the other political parties. We may note that the recognition of nota by this court enabling a voter to express his distrust for all the candidates exposes the disenchantment with the electoral process which hardly augurs well for democracy. Therefore, any action or omission by the election commission holding the poll which treats political parties with an uneven hand and what is more, in an unfair or arbitrary manner would be anathema to the mandate of Article 14 and would therefore cause its breach. There is an aspect of the citizen's right to vote being imbued with the fundamental freedom under Article 91A. The right to the citizen to seek and receive information about the candidates and who should be chosen as by him as his representative has been recognized as a fundamental right. What is independence? Independence is a value which is only one of the elements in the amalgam of virtues that a person should possess. The competence of a man is not to be conflated with fierce independence. A person may be excellent, that is, at his chosen vocation. He may be an excellent administrator. He may be honest. But the quality of independence transcends the contours of the qualities of professional excellence as also the dictates of honesty. We may no doubt clarify that ordinarily, honesty would embrace the quality of courage of conviction, flowing from the perception of what is right and what is wrong. Irrespective of consequences to the individual, an honest person would ordinarily, unrelentingly take on the high and the mighty and persevere in the righteous path. An election commissioner is answerable to the nation. The people of the country look forward to him so that democracy is always preserved and fostered. We may qualify the above observation by stating that true independence of the body of persons is not to be confused with sheer unilateralism. This means that the Election Commission must act within the constitutional framework and the laws. It cannot transgress the mandate of either and still claim to be independent. Riding on the horse of independence, it cannot act in an unfair manner either. Independence must be related finally to the question of what is right and what is wrong. A person who is weak-kneed before the powers that be cannot be appointed as an election commissioner. A person who is in a state of obligation or feels indebted to the one who appointed him fails the nation and can have no place in the conduct of elections, forming the very foundation of the democracy. An independent person cannot be biased, holding the scales evenly, even in the stormiest of times, not being servile to the powerful, but coming to the rescue of the weak and the wrong, who are otherwise in the right, would qualify as true independence. However, it is equally clear that Article 324 has a unique background, as correctly clear, as a unique background. The founding fathers clearly contemplated a law by Parliament and did not intend the executive exclusively calling the shots in the matter of appointments to the Election Commission. 7 decades have passed by. Political dispensation of varying hues, which have held the reins of power, have not unnaturally introduced a law. A law could not be one to perpetuate what is already permitted, namely the appointment at the absolute and sole discretion of the executive. A law, as Gopal Shankar Narayan points out, would have to be necessarily different. The absence of such a law does create a void or vacuum. This is despite the chorus of voices, even cutting across the political divide, urging divesting of the executive power of the appointment from the executive, exclusive power of appointment from the executive. We have noticed that while making a law is ordinarily a power with the legislative branch, and being a power it cannot be coupled by the court, the making of the law may be a constitutional imperative. In the context of Article 326, making of law as contemplated in Article 326 was an unavoidable necessity. Realizing that the statutory framework was necessary to breathe life into Article 326 and which was not to be incongruous with this command, Parliament enacted the 1950 Act and the 1951 Acts. The first general election followed. Making of law by Parliament, as provided for in Article 146 and Article 229, dealing with conditional service of employees of the Supreme Court and the High Court respectively, was a sheer power and enabling provision. The context and the purpose signals no imperative need, no intention to indeed peremptorily provide for a law as is discernible in the case of appointment of the members of the Election Commission of India pervades the articles. The vacuum in the case of Article 324(2) is the absence of the law which Parliament was contemplated to enact. Political parties undoubtedly would appear to betray a special interest in not being forthcoming with the law. The reasons are not far to seek. There is a crucially vital link between the independence of the Election Commission and the pursuit of power, its consolidation and perpetuation. As long as the party that is voted into power is concerned, there is not unnaturally a near insatiable quest to continue in the saddle. A pliable election commission, an unfair and biased overseer of the foundational exercise of another franchise, which lies in the heart of democracy, who obliges the powers that be, perhaps offers the surest gateway to acquisition and retention of power, The values that animated the freedom struggle had to be brought home to a new generation through insertion of the provision relating to fundamental duties. Criminalization of politics, a huge surge in the influence of money power, the role of certain sections of the media, where they appear to have forgotten their invaluable role and have turned unashamedly partisan, call for the unavoidable and unpostponable filling up the vacuum, even filling up of the vacuums. Even as it is said that justice must not only be done, but seem to be done, the outpouring of demands for an impartial mode of appointment of the members require at the least the banishing of the impression that the election commission is appointed by less than fair means. It comes to the final thing. There cannot be any doubt that the Election Commission of India is to perform the arduous and unenviable task of remaining aloof from all forms of subjugation by and interference from the executive. One of the ways in which the executive can bring an otherwise independent body to its knees is by starving it off and cutting off the requisite financial wherewithal and resources required for its efficient and independent functioning. It would not be unnatural if faced with the prospect of it not being supplied with enough funds and facilities. A vulnerable commission may cave in to the pressure from the executive, and thus it would result in an insidious but veritable conquest of an otherwise defiant and independent commission. This apart from the fact that cutting off the much needed funds and resources will detract from its efficient functioning. Finally, the repetitions are partly allowed and they are disposed of as follows. We declare that as far as appointment to the post of Chief Election Commissioner and the election commissioners are concerned, the same shall be done by the President of India on the basis of the advice tendered by a committee consisting of the Prime Minister of India, the leader of the opposition in the Lok Sabha, and in case there is no such leader, the leader of the largest party in the opposition in the Lok Sabha, having the largest numerical strength, and the Chief Justice of India. This norm will continue to hold good till a law is made by the Parliament. As regards the relief relating to putting in place a permanent secretariat for the Election Commission of India and charging its expenditure to the Consolidated Fund of India is concerned, the court makes a fervent appeal that Union of India Parliament may consider bringing in necessary changes so that the Election Commission of India becomes truly independent. This was correction. Pages which I had to sign.
Assume, Lord, that that's the authentic.
I entirely agree with
There are my highlights. Then you proceed with your. My brother is done.
Yes.
I entirely agree with the conclusion which my erudite brother has drawn based on the remarkable process of reasoning with my additional conclusions. Agreeing on the appointment of a committee, I had were more suggestions to make, and particularly insulating the election commissioners. In order to allow independence in the functioning of the election commission as a constitutional body, the office of Chief Election Commissioner as well as the election commissioners have to be insulated from the executive interference. And this is envisaged under the proviso to Article 324(5) of the Constitution. There are two procedural safeguards available regarding the removal of the CEC. First, shall not be removed from his office except in like manner and on the like grounds as a judge of the Supreme Court. And second, the conditions of service of the Chief Election Commissioner shall not be varied to his disadvantage after his appointment. However, second proviso to Article 324(5) postulates that the removal of the election commissioners would be made only on the recommendation of the Chief Election Commissioner. The protection available to the Chief Election Commissioner is not available to other election commissioners. Various reports have recommended that the protection against the removal available to the Chief Election Commissioner should be made available to other election commissioners to ensure the independence of the Election Commission. Then I have reproduced certain reports of 2004 followed with 2010. The Office of the Election Commission is an independent constitutional body which has been vested with the powers of superintendence, direction and control of the preparation of electoral rolls and the conduct of all parliamentary and state legislative elections, and that of the office of the President and Vice President in terms of Article 324(1) of the Constitution. In terms of Article 324(2), the Office of the Election Commission comprises of Chief Election Commissioners and such other number of other election commissioners, if any, as the President may from time to time fix. And by an order dated 1st of October 1993, the President has fixed the number of election commissioners to 2 until further orders. Since 1993, it is a multi-member commission with equal participation in transacting the business of the Election Commission as provided under Chapter 3 of the Act 1991 to ensure the smooth and effective functioning of the Election Commission. Article 324(5) of the Constitution is intended to ensure the independence of the Election Commission free from all external political interference and thus expressly provides that the removal of the Chief Election Commission from office shall be in like manner as on the grounds of a judge of the Supreme Court. Nevertheless, similar procedure has not been provided for the election commissioners and the second proviso to Article 324(5) of the Constitution. However, the other conditions of service of Chief Election Commissioner and the election commissioners have been protected by the legislature under the Act 1991. In the facts and circumstances, keeping in view the importance of maintaining the neutrality and independence of the Office of Election Commission to hold free and fair election, which is a sine qua non for upholding the democracy as enshrined in our Constitution, it becomes imperative to shield the appointment of election commissioners and to be insulated from the executive interference. It is the need of the hour and advisable, in my view, to extend the protection available to the Chief Election Commissioners under the first proviso to Article 324(5) to other election commissioners as well, until any law is being framed by the Parliament. Agreeing on the constituting the committee, my further directions which I have brought in is, it is desirable that the grounds of removal of the election commissioners shall be the same as that of the Chief Election Commissioner, that is on the like grounds as judge of the Supreme Court, subject to the recommendations of Chief Election Commissioner as provided under second proviso to Article 324(5) of the Constitution. And the conditions of service of the election commissioners shall not be varied to his disadvantage after appointment. So I am in agreement with the view, but in addition to it, is my additional view on the insulating election commission.
The IAs will stand the case.
Lord, I just wanted to, I'm very grateful for this salutary and very erudite judgment. But that one IA, which was that the pending vacant post of one of the election commissioners.
Not, you have not seen what we have. Please read the whole document.
Acha, all right.
I mean,
Your Lordship has
not to be
dealt with this issue.
We have dealt with many other aspects.
That is
We
taken
don't
care
have
of.
the time to read.
Acha, all right, very well.
We have, including, we can say now, we have also proceeded to find the constitutional right, but because of the conflict with the 5 judges bench, judicial discipline, kindly go through. I mean,
Very well.
find many things.
No, we are very grateful, my Lord, for such a patient hearing and thereafter such an erudite judgment.
Thank you.
Grateful, my lord.